Good morning. Is it on? That's on. It's louder. All right. Good morning. Okay, I hope everyone had a nice weekend. Thank you for bearing with me. Can you hear me on the lavalier mic in the back? Yes? Good? Okay. Thank you for being patient. Last week, my son is doing better, so we may schedule a makeup class. I will be back in touch on that. This morning, Spotify shares have started, it looks like, to trade in their unconventional IPO. Keeping an eye on that on Twitter. Just came in Reuters that the trades may open at 155 to 45 to 155 above the reference price of 132. That's nice. Let's see what happens over the next couple days. It'll be a fun point to circle back to on maybe Thursday or next week. Today, however, we are talking about insider trading. So we're going to try to get through all of the cases today from Dirks to Martoma. Let's see how it goes. Let's start with Dirks, and I just so that we're all kind of remembering the conversation of insider trading where we are, just sort of refresh. We discussed both the classical and the misappropriation theory. We said that the classical theory was based on the notion that trading in the shares of a corporation to which the insider owes a fiduciary duty to the shareholders of that corporation would be the sort of fraud that would give rise to a violation of Rule 10b-5. And we said that the classical theory, as was articulated in Katie Roberts, really required a duty to be present, a fiduciary duty between the insider and the shareholders of the firm that the insider was buying or selling without disclosure. As we saw in Chiarella, that only took us so far. In the case of Chiarella, which involved a printer who had been given confidential information from an acquirer and ended up trading in the target firm's shares. And that redirection, if you will, of the trading activity from the shares of the target, from the shares of the acquirer to the shares of the target, that is the fiduciary duty that the printer had. If it existed vis-a-vis the acquirer, but in fact he traded in the shares of the target where there was no fiduciary duty. And as a result, we learned that Mr. Chiarella was not held liable. We then talked about O'Hagan, which involved a lawyer who was trading on information about an acquisition that he received. And in O'Hagan, the court articulated this misappropriation theory, which was based on the violation of a fiduciary duty owed to the source of the information. And so we concluded our conversation last week by talking about the misappropriation theory and really the boundaries of sort of the fairness and information symmetry that seems to be motivating the court, and the challenge that the court has articulating a doctrine of insider trading that fits nicely the original anti-fraud prohibitions of 10b-5. And we said that the problem that's going to sort of animate insider trading law at a high level is that a statute that was meant to prohibit fraud in the purchase or sale of a security is being used to prohibit trading by individuals who, when that trading doesn't really involve any fraud, as it seems, other than non-disclosure of material non-public information. And that challenge, sort of finding the kind of insider trading that we want the law to prohibit, is what's going to animate this entire discussion of tipping liability. Because unlike the classical or the misappropriation cases that we looked at so far, here we're talking about trading by individuals who have no fiduciary duty. This is the key point. No fiduciary duty either to the corporation's shareholders, that is the shareholders of the corporation in whom they are trading, or to some source of information, that is these individuals who are trading did not receive information pursuant to a duty of confidentiality. They never pledged to keep the information confidential that they received. And it's that difference, right, that we're talking now about individuals who we'll call tippees, who just receive information without having made a promise to the source of that information, to the target or the acquirer in an M&A deal. It's that difference that takes us out of the classical and misappropriation theory as we've learned them so far. And the challenge is going to be to articulate the scope of insider trading liability that prohibits, if at all, trading by remote tippees, so to speak, or individuals who receive information from others who may have that fiduciary duty. And what we see in these cases is the courts trying to reconcile, trying to grapple with how far should we extend insider trading liability. All right, so with that introduction, let's talk about Dirks. So who would like to tell us about Dirks? Yes, Amy. Oh, everyone here? Yeah. Great, great. So Mr. Dirks fashions himself to be a sort of, corporate good Samaritan, right? Now, Amy, what was the key point that the court really emphasized when well, first of all, was Mr. Dirks held liable? Yes or no? No, right. So why not? What was the point that the court found most convincing in Dirks' behavior or the behavior of those other individuals that really sort of was the linchpin to the decision?
That nobody was trying to put secrets and Dirks weren't trying to get the advantage of themselves.
Great. So the starting point for thinking of what's really motivating the decision in Dirks is the fact that the actors here, Sechrist, this insider at Equity Investments, a former officer of equity funding, was motivated by a desire to expose fraud. Now, this subjective motivation is kind of an interesting gloss because, I mean, this is my next question. Was everyone purely altruistic? I mean, did anyone make money as a result of Dirks' sort of discovery of this fraud?
Yeah, I mean, Dirks probably made money too, right? Because his clients who traded on that info, so he got a commission or something from it.
Right.
I'm not sure about Sechrist.
Right. So we're told that Sechrist, as far as we know, we're told that on pages 1185 of the case book that the tippers here talking about Sechrist or the other equity funding employees received no monetary or personal benefit for revealing Equity's funding secrets, nor was their purpose to make a gift of valuable information to Dirks. Now, so the first part of that sentence would lead us to think, well, the tippers aren't themselves perhaps trading on the information. So that's good, so to speak, right, for Dirks. The second half of the sentence, though, nor was their purpose to make a gift of valuable information to Dirks. I mean, what do you think about that? Do you find that convincing?
Yeah, I don't really find that convincing.
Yeah.
Everybody knew what was going on here, and with difficulty, presented in the industry, so they kind of gave Dirks that heads up to help them out.
Yeah, and was the information valuable?
Yeah, it was
Yeah.
valuable, right?
I mean, the price fell, right? This is back in the recitation of the facts.
Yeah, so they made the people who liquidated their holdings $600,000.
Yeah, and in fact, exactly. And in the next paragraph, we see the price fell from $26 to $15 a share. So that information, right, was really valuable. Okay, so there's kind of an interest. This is sort of the interesting starting point before we get into the analysis in the flowery doctrine that the court develops. But this is basically at the level of the facts of Dirks. A lot of people were making a lot of money, right? And so was there evidence, and this is the key question, that the insiders, let me put it differently, how can we think of this idea that the insiders were not motivated by a desire to confer a gift of valuable information. I mean, at the end of the day, right, if I'm giving you information that is going to reduce the value of the stock by $11 a share, how is it possible for the court to conclude that they were not motivated by it? I mean, is there evidence as to their subjective motive? I mean, what do you think is driving this sort of conclusory, so to speak, point that the court's making?
I think what's going on here is that there's not like smoking gun evidence that it was like a quid pro quo, like
Yeah.
unlike what we have in Solomon, where there was more like testimony of like, oh, I did it to help my brother, like
Yeah.
nothing on that. And then I think what's happening at this point in time in the what is it, like 80s, like the court is just trying to reward them for like uncovering this fraud.
Great. I think that's right. Does anyone else have a thought on this? Sam, what do you think?
So there was also evidence that the tippers had tried to spur an investigation by regulators and had been turned back from that. So it seemed that they first went to regulators and then went to Dirks because the regulators wouldn't respond.
Yeah. So this is kind of interesting, right? So you have a bunch of individuals who, I guess, like good Samaritan types in the eyes of the court. So there's this. I think the case books is like good. What is it? Good cases make bad law, or so. So this is a really challenging case to define the scope of insider trading liability, right? Because what you have are a bunch of actors who are trying to uncover fraud. They're talking to they're talking to regulatory agencies. It's not working. They think, well, if I just get in a hedge fund, well, an analyst involved, if I get an investor involved or someone connection to the investment industry, maybe that will shed light on it. Why? Does anyone find that sort of, let's just start at the level of trying to understand the kind of intuitive characterization of the players here. Does anyone find that characterization, that good Samaritan characterization, not persuading? Yes. Let me check you off. Yes.
My problem with it is it just sets a bad precedent. What's to stop them from going to the regulators and then immediately turning around and telling their clients, dump, 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 because then you get kind of the best of both worlds.
Right. Was there something else that these poor folks could have done? Like, I'm trying to almost hyperbole, sort of like a caricature, so to speak, of this. But think about it. Was there something else they could have done besides tell Dirks about the fraud? Yes.
Yeah, well, I think there was like a Wall Street Journal article that was published like after sort of the SEC investigation was, the complaint was filed. And it seems like Dirks provided the SEC a lot of the information, so I don't know why the insiders couldn't have just gone to a newspaper on their own and done that.
Exactly. Why not hold a press conference? Okay? So there's something a little suspicious about this idea that these folks are just sort of trying their best to uncover fraud. And the only way we can do that is by tipping off an analyst so that he and his pals can make $16 million on it. Yes, Mike.
Isn't there some risk to that approach, though? If you were incorrect about the fraud, couldn't you be charged for like stock manipulation or other? It seems to me that's not always a viable alternative.
Well, let's think about that. So could you been charged with market manipulation if you just went out and held a press conference and said, let's announce to the world that there's fraud? Well, you might be defamation liability, or maybe. I mean, there would be First Amendment concerns. Yeah, Elliot. Yeah. Exactly. That's exactly right. So the reason why you wouldn't go out and disclose is because you want to use this information in some way. Now, maybe it's because you want to keep your reputation for being sort of a good citizen or not a troublemaker, so you're going to kind of keep it quiet. Maybe it's because in the more aggressive construction, you want to go out and sell that information in some way. Whatever the story, the idea that they're not motivated by a desire to make a gift of valuable information is a pretty strong inference, right? And we don't have really affirmative evidence. Yes? Yeah.
a bad taste in your mouth, what's your duty if you know there was fraud?
Yeah. Well, so sort of another way to ask the question is, imagine he had just emailed the Wall Street Journal, right? It said, well, hey, well, email at the time they didn't have, but, he sent a telegram. I don't know, what did they have? A fax machine? So he sent a fax, fax or stuff, picked up the phone, okay, and said to the Wall Street Journal, I found something out. I know something about equity funding. Now, there'd be an interesting question, and this is maybe kind of what's motivating this a little bit, whether that would constitute public disclosure, right? So we saw this in the investors management case. There's this question about when, right? Because that was when they had made the announcement to the Wall Street Journal, and they had sent the telegram, right, to the Wall Street Journal or to the Dow Jones Newswire, and it didn't get delivered. And so that was actually the basis for the non-public characterization of the information. Right, so there might be a problem if you want to trade immediately with relying on a reporter, because that reporter may not publish the news. And there might even be, you could go so far as to say, well, if the reporter doesn't ever publish the news, then it will never make its way out. So I'm putting my news in the hands of a reporter. But if it's this market moving, we're talking about $11 a share value, that's half the price almost, right? You'd think they'd probably write something about it. All right, one more comment on this and we'll move forward. Yes, Sam.
Yeah, so I'm not sure if that would be a viable option in all cases. So in this case, Dirks actually, upon receiving the information, went to the Wall Street Journal, but they initially refused to publish the article because they were concerned about libel. So,
yeah, okay, so the libel, great. So Sam points out that it's not always easy to get reporters. That doesn't mean that there's no other way to publish the information, right? Or that there's no other way to make it public. Because if you really want to be sure that you're not subject to insider trading liability, announce it, right? Announce it. And then you can trade all you want. There's actually a cottage industry today of activist short sellers. Does anyone, are any of you familiar with these folks? So there's this, it's actually interesting. I've been thinking about studying this. So you have these folks, many of them have anonymous names. So it's like the street sweeper, or the Falcon investor, or the bubble popper, And what do? They go out and they find companies that they think have fraudulent valuations that are like too high relative to what's really going on, and they announce that the company is worthless. And here's why. We're going to give you a 20-page report as to all the problems with this firm. And they have a short position in the firm, often prior to announcing that report. They could also have just, sold short the company right after releasing that kind of a report. In any event, once you make the information public, you really don't have to worry about insider trading liability. And so if your goal is to bring that information to light, that's a question we want to ask. But you're right, Sam, maybe it wouldn't have worked because that was an era where we didn't have as much direct access to the press, and the Wall Street Journal was concerned about defamation liability. So you're right, maybe there was no other option, and maybe that's what's motivating the court here. Okay, so Amy, let's move forward with just the analysis. So what's the sort of canonical articulation here in Dirks of whether or not a tippee assumes fiduciary duty? When is the tippee liable for insider trading per Dirks? Yeah. So formally, let's just sort of make sure everyone has the elements clear here. Formally, all right, the tippee assumes a fiduciary duty when two conditions are present. The first is that the insider or the tipper has breached their fiduciary duty. But before we get into what constitutes a breach of the insider's fiduciary duty, remember that there's a second element that the tippee must know or have reason to know or should know that there has been a breach of the tipper's fiduciary duty. So I'll just say that one more time. You need to show two sort of general elements, right? Element one is that there has been a breach of the insider or the tipper's fiduciary duty to the shareholders by the disclosure of the information to the tippee. So by telling the tippee this material non-public information, element one is that you have to show that that was a breach of the tipper's fiduciary duty. Element 2 is that the tippee knows or should know that there has, in fact, been a breach. Now, the question now, as Amy pointed out, is when is the insider's tip a violation of his or her fiduciary duties? And you said it is? Yeah, so the test, there has to be some personal benefit. Absent some personal gain, the court tells us there has been no breach of duty to the stockholders. All right, so that kind of makes sense, I think, right? If you say, well, all right, so if I am an insider, and remember, go back to O'Hagan, and we said what was really bothering the court in the misappropriation story was that you were given the information for a particular purpose. In the case of O'Hagan, it was to facilitate a transaction as a lawyer, well, the firm, and you learned about it through your access to material non-public information at the firm. So there's this sort of sense of theft, right? This sense of stealing something that isn't yours when you convert this information into profit. And so the personal benefit test, this articulation of tippee liability as turning on whether or not the tipper receives a benefit from the tip, fits kind of nicely with the story that insider trading liability is based on a notion of property rights and information, that the firm sort of owns its information, and when it shares that information for a limited purpose, the recipient is not entitled to just go convert that information to profit, or at least in the context of securities trading, converting that information to profit in the purchase or sale of a security will violate 10b-5. Now, Victor Brudney, in the Harvard Law Review, sort of articulates this nicely, and the court quotes it, right? The theory is that the insider, by giving the information out selectively, is in effect selling the information to the recipient for cash, reciprocal information, or other things of value for himself. Now, based on that statement by Brudney, we then get to the sort of different ways the court articulates that the personal benefit might be established. So, Amy, what's the first? So the court kind of lists a few examples. Okay, so what's the first example that were given in Dirks? Yeah, so we have a gift of confidential information to a relative or friend. What else? That's actually the second. Oh, there's one before that, one that fits Brudney's sort of. Okay, does anyone else have this? The QPQ, quid pro quo, right? So the court's saying, look, if there's a quid pro quo, so first they cite Brudney, right? They say, it's really giving the information is in effect selling the information. And of course, the case that fits that really nicely is when there is actually a quid pro quo. So I'll give you some information about the company, you give me some dough, and there's been a deal. That clearly is a personal benefit to the tipper. The next example the court gives is the gift of confidential information to a trading relative or a friend. Now, here's where Dirks starts to go off the rails a little bit. All right, so this is the sort of original sin, right? This is where everything kind of begins. Amy, how is a gift of confidential information to a trading relative or friend equivalent to selling the information to a recipient for cash, reciprocal information, or a thing of value for yourself? Like, how do those two connect? Yeah. So one theory, and this is now sort of in the realm of speculative kind of reasoning, because it's not really spelled out, but it is spelled out in other cases by the Second Circuit, and that's one that we see also featuring in Newman. which you didn't have in the readings, but kind of makes its way into Martoma, which is this idea that if my relative or friend benefits, I benefit too. I'll just think about that for a second. That's, for me at least, that one takes a second to really, I'm not sure I fully buy it, all right? Maybe some of the time. Do you buy it? Do you think all the time when your relatives benefit, you benefit? Okay. Yeah.
You do benefit if your brother-in-law is like trading on that information. I mean, you kind of don't benefit. Like, I'm not saying they give you a cut of it, but
Right.
we're trying to circumvent certain activity, making you liable for it will make you more careful about what you say to them irrelevant.
Exactly. I completely agree that if we reason sort of the end justifies the means, right? We sort of consequentially reason and say, well, what we want to do is prohibit trading, tipping as a means of sort of circumventing trading, then, yeah, let's say, wink, wink, that if my brother's better off, then I'm better off. I mean, what if you're, like, estranged from your brother? Right? It's a pretty loose, okay, so how many of you find this persuasive? Okay, yeah. Yeah. And what if it's like a good faith gesture? You know, I mean, we haven't talked to each other in 5 years, and call you up and I say, hey, buddy, you know, I wanna get back in touch. Go buy Tesla. I don't know. You know? Yeah. He says, you know, I don't want to talk to you, but he goes and buy, right? I mean, yeah.
Well, that kind of brings up the other justification of it, which is like it's like a cash gift. So that would be like, oh, we've been trade for 5 years. I'm giving you this information so you can make money off of it. But whatever money you make is basically like a cash gift from me.
Yeah, that's right. So a cash gift would be wonderful for my brother. Would definitely enjoy the gift. How is a cash gift to my brother a benefit to me? Yeah. Nice. Yeah. Good. So empirical methods. Yeah, very good. Very good. Yeah, I like that. Yeah, that's right. Yeah.
Also, something that doesn't come up, I think, until Martoma is sort of this idea that why would you take a risk that exposes you to serious liability for absolutely no gain whatsoever is sort of an illogical step.
Great. So Ben points out that the courts like to reason this way, that there would be no reason you would do this sort of very risky move of sharing material non-public information if you weren't getting something out of it. But Ben, I mean, if I assume that the law is what the law is as of Dirks, that is that if I give the information to my estranged brother expecting nothing in return, document that. And in fact, he will do nothing for me in return. Aren't I assuming that I will not be liable for insider trading? So from my perspective, it's a no-risk proposition, right?
I think but the court would basically say that's an implausible fact pattern. That scenario doesn't happen.
No. Yeah. Okay. Sam.
This is just a question. Is there any case law on like anonymous tips? Like, what if you were to just give your brother a tip, never reveal that it was you, and then presumably you wouldn't receive a benefit?
That's cool, right? So anonymous tips. So the brother doesn't know it's me, but it's still a gift to a trading relative or friend. But they don't know that I'm the relative. That's fun. Alistair, yeah. I don't know.
Yeah, I think in that kind of circumstance, you talk about the benefit being derived as Not necessarily a benefit that your brother does for you, but a benefit that you get from providing help to your brother. So presumably if you're doing this to your estranged brother, he probably needs the money, and you can derive a benefit from that that isn't coming from the brother, but might be now that the brother has this money, you're getting these indirect familial benefits or something like that.
Yeah, so we gotta articulate, okay, the story of indirect familial benefits or the psychological payoff of gift giving is, sort of altruism is actually not altruistic. It's actually, makes me better off. Maybe some of the time I buy that, so I'm not sure all the time. Anyway, think about tax law, okay? So there are many other places in the law where gift giving is not actually construed as implying any benefit for the giver. So if you give a gift, like say you give a $100 gift to your brother, I mean, as I'm in tax law, we don't say that, 23% of that was your altruistic payoff, and therefore your income should be increased by $23, right? I mean, the idea that a gift bestows a benefit on the giver could be plausible, but it requires a kind of stretch and a construction and a sort of story that we really don't see in other places. Does anyone disagree? Do you think everything I'm saying is completely nuts? Felix doesn't look persuaded. What do you think, Felix?
I'm really not sure why we care about the justice of the situation, because if the goal of the court is to kind of the court's treating insiders as sophisticated actors, and to an extent they're presuming benefit whenever it's plausible that the insider is benefiting from this thing. That doesn't seem crazy to me if the court is, we can, this might not fit into like broader theories of economic efficiency, but there's also some kind of underlying gut sense of justice that people shouldn't be able to kind of profit from information they receive in the context of confidentiality, and you might presume profit, you might go overboard in defining profit because these are people who are deeply sophisticated actors, frequently incredibly well compensated, and courts just aren't terribly sympathetic to them.
Yeah, great. So Felix gives the most realpolitik explanation, which I think is completely persuasive, which is that, at the end of the day, what's bothering the courts here is like a prophylactic concern. It's like we kind of wink know there's no personal benefit in a lot of these cases, or there might not be. But we're going to kind of tell this story that gives us a sense that we're sort of righting the injustice where the wealthy are benefiting the wealthy, and we kind of don't think it's fair. And I think that's exactly what's motivating. And personally, that's my personal view. Yeah, Michael. Oh, you're just stretching. Okay. Yeah. So yeah, I think that's probably right. Now the problem is, and what we see in Newman and then Martoma is like you got to define who's in and out, and these are criminal statutes at the end of the day, right? 10b is a criminal violation. These are folks being put. Matthew Martoma was put 9 years behind bars. So these sort of loose intuitions about what's fair or not, and we need to kind of prophylactically sort of, call a lot of stuff a personal benefit. I don't know. I mean, we're talking about people's lives here. Amy, one second. Yeah. Yeah. So let's think about that, Amy. Why not?
Well, it depends. It depends on like what we want about like what kind of behavior we want to reward.
Yeah.
We want to reward the like hedge fund analyst who's going to go out and maybe like spend a lot of cost and money gathering the information with investors who are more like fair and productive, and like anyone can go to a shopping center and observe like how like a store is doing Burlington Coat Factory, but like not anyone has access to like Sullivan and Cromwell.
Yeah, I mean, it's probably true that the Sullivan and Cromwell associates go to some expensive bars, and so probably the hedge funds who are capable of sort of cozying up to them need a lot of cash. But, you know, a lot of cash means you can move prices. Let's think about this. Suppose you bought equity funding at $26 or $25 as it's kind of slowly creeping down to 15. And you bought it at 25 while you waited as you watched your money cut in half. Wouldn't you kind of wish that that hedge fund pal of the lawyer in your story or Dirk's buddies had gone out and sold short that stock so quickly so that it dropped to 15 before you could buy it? What about that poor soul? What do you think? Yeah. So what do you guys think? So does anyone else have sympathy for the sort of buyer of equity funding at something above $15? I don't know, 20, 21, 22, 23. Does anyone else? No sympathy? No, because I can't when I trading. None. It's a risky market. Good. Yeah, that's good. Okay, so yeah, so the theory is kind of working, right? Yeah. Okay, so you should be diversified. So you're just as likely. Remember, we talked about this in the beginning. You're just as likely to overpay for the equity fundings of the world. That is to pay $23 for the companies worth 15, as you are for the companies that to pay $15 for the company worth 25. Maybe, right? Maybe. It's not clear 100% that you can fully diversify away this kind of fraud risk. But there's a good argument that we shouldn't be too troubled. But if you took that argument to its conclusion, maybe we shouldn't be worried about insider trading at all. Because the same logic would apply to the insider who's getting to pocket the cash. Yes?
I was just going to add that I think that the law can't really deal with that insider or that non-insider that we feel bad for anyway, because even if the information were perfectly disclosed through the Washington Post, the people who would be able to trade on it fast enough would be the people who see it first, who have analysts on it, which are already the big wealthy hedge funds and institutional investors. So by the time that little guy who bought it at 25 gets to the information, it's already been traded down, most likely to its real price at 15. So he probably loses that money anyway. And on the second half, you probably want to incentivize having at least some connection with insiders, because otherwise you kind of wonder how these analysts are going to get their information in the first place.
So I think I understand you to be saying if we, the little guy, so imagine that on Monday, the price is 26, Dirks is going around talking to his buddies, and the law is such that Dirks, and his friends are able to kind of slowly insider trade their way until the price hits 15 on Friday. And I'm saying, look, there was someone out there who bought on Tuesday, right? Now, the question is, if we're concerned about personal benefit, we're saying, look, we really don't think it's fair to let Dirks and his buddies trade on the information if they receive a personal benefit. Kind of think of that as a braking mechanism on the trading, because there'd be some trading that could occur but for that rule. So we can think of the personal benefit test as kind of slowing down the speed. And I'm saying, look, if we didn't have a personal benefit test, or we didn't have a prohibition on insider trading, that is, if we made it easier for folks to trade, one way to think about it, then, in fact, that price might update more quickly. And so that poor soul who bought it at 24 on Tuesday might, in fact, be buying it at 15 or 16. Now, that makes him better off, because he's not going to lose $10. So my point is just the equities, going back to Felix's articulation of the fairness concern, the equities here are really difficult to balance. They require a lot of speculative assumptions about who is buying when, what sort of trading the law slows down. But I want to move forward. I want to focus on the other articulation that the court gives, which is the one that sticks all the way through Salmon and even to Martoma, which is that, in fact, all we have to do is look at the text of Dirks. And there's a quote here: the tip and trade resemble trading by the insider himself, followed by a gift of profits to the recipient. So I want us to focus on this rationale, because I think you will agree the other ones are kind of tricky, but this one is pretty clear. And it ends up serving as the anchor for the Salmon and Martoma decisions down the road. And it's this simple idea that if you trade, you are trading and making money. If you tip, you are performing an action, at least most of the time, that's kind of equivalent. Because what you're doing is you're giving information that allows the recipient to trade on that information. So it's kind of like you traded, got the cash, and then gave the cash to your recipient, right, to your tippee in this story. That articulation in Dirks really doesn't turn, notice carefully, on the receipt of a personal benefit by the tipper, except for this transitory moment, right, when the tipper, in the hypothetical analogy, would have traded, pocketed the cash, and then given the cash. So what Dirks is really introducing is this idea. I'll give you kind of an analogy. It's kind of like you walk into a candy store, and you take the candy off the shelf, put it in your pocket, walk out the door. Now we know, it's a matter of criminal law, that the theft of the candy is complete as of that moment. It does not matter that you then turn around after exiting the front door and give the piece of candy back to the shop owner, right? Legally, it does not matter. Economically, it matters a lot. Because economically, if you make restitution, or if you put the shop owner back in the position they were before the theft, you have in fact inflicted no economic damage on the store. But legally, there's a distinction. And it's this idea, I would suggest, that's really motivating the court. It's this notion that we're going to identify a benefit not by any economic test of whether you really benefit economically, but by a legal construction that your trading would have given you the cash, however ephemerally, however momentarily, and thus your tipping is functionally equivalent to having traded and had that cash for but a moment. Bless you. And it's that notion that we really view these as the same thing. I would suggest that underlies Dirks. And we see that coming up over and over again. The court really likes this story, that tipping is equivalent to trading and giving the cash, even though trading and giving the cash makes you no better off economically. There's a legal characterization of that at a moment in time when you trade, the money was yours. Just like you walk out the candy store, and the moment you walk out the door, you've stolen the candy, even though you could put it back or you could give it to someone else. Davia. Right. Exactly. Exactly. That you could have done this yourself, but you sort of deputized your friend to do it for you. And lawyers don't like that, right? Lawyers don't like that. It feels like you're trying to make an end run around a prohibition, even though there may be no evidence of that. But we don't like that. Does everyone see that? Felix.
Never mind. This is too off topic. I'll talk about.
Well, I'll just finish up. We'll finish Dirks here. Just one more point. Think about the following critique of that construction. The difference between. Well, let me say it different. Let me try to continue the analogy. Let's continue the candy store analogy for a second. Maybe this will help. The court is kind of drawing a parallel between sort of stealing and giving the proceeds of what you steal, and telling someone about an opportunity to steal. And this is really a distinction I want you to keep in mind. When you gift the information, you're not trading. You're telling someone about an opportunity to trade. That is speech, right? Not conduct. For the First Amendment folks in the room, right? So think about that for a second. That tipping liability, in a way, is kind of premised on a equivalency, at least in Dirks, between behavior that unequivocally constitutes theft, trading on the information. I mean, not in Dirks, but in general, trading on the information would be a violation of the classical misappropriation theory. But we're going to make that equal to telling someone about an opportunity to steal. It's kind of like the idea here. And that is a parallel between behavior or conduct and speech that could facilitate that sort of behavior or conduct. And that is a very tricky parallel to draw. You want to think about that, because in many settings, like, we talked about cybersecurity, for example. What are we trying to regulate in that conversation? Disclosure, speech about vulnerabilities, right? And there's something about the jurisprudence in this area where the courts are trying to bring those two together and say, talking about, exposing information is equivalent to actually acting and behaving in a manner that we all agree is prohibited. And that's a big step. That's a big step analytically. Yeah, Ben.
I hope you don't mind. Can I push back a little bit on that?
Great,
Because
please.
I'm not sure I see the parallel, because it's not actually prohibited until trading gets done. So it's different than to me, it feels different than the cybersecurity example, because that's truly the regulation of information. In this case, this is not the regulation of possession of information or passing on of information, but the regulation of the use of the information. So I could tip 100 people, but if they don't trade, then there's no liability in it for me, aside from whatever personal liability may be to my corporation. But that's not what the securities law is about.
Fair. So Ben correctly points out that tipper liability is derivative. Well, tippee liability is derivative to the tipper's breach of fiduciary duty, but for 10b-5 to apply, we need the purchase or sale of a security. So in the hypothetical where there's no purchase or sale of a security, there's no 10b-5 violation. That's right. It's also correct, though, that the breach of fiduciary duty element is satisfied purely by the tip. And this is an important analytical point. So you're right that at the end of the day, liability won't attach if there's no trading, if there's no purchase or sale of a security. It's also the case that the court's justification for finding a breach of fiduciary duty by the tippee begins with the tipper's breach of fiduciary duty that consists solely of speaking. And that is a big step, right? In fact, it's not the kind of analysis we've typically employed in the anti-fraud setting, where we've usually said that disclosure is how you prevent fraud, in a way, right? So in other words, most fraud, sort of at the common law, is based on non-disclosure. So you can understand how far the doctrine has gone in this area away from the common law fraud paradigm by thinking about the fact that we're turning speech into a violation of a fiduciary duty. And not because, critically, necessarily, you yourself, as the speaker, broke a duty of confidentiality that you took on. Some of the time that will be present, but we can get remote tippies merely because each chain in the tipping chain, right, inherited the fiduciary duty of the preceding chain. And that is enough. And the logic, the rationale for that is that is equivalent to having engaged in the behavior yourself That equivalency is a big step analytically. Okay, yes, Michael.
Someone still ultimately has to commit the insider trading, right?
Yeah.
Just giving the information and not doing it is...
Absolutely. Okay. Absolutely. But how we get there? Okay, I'll take one or two more. And let me get in the back. Yes.
So is this fiduciary duty is this state law fiduciary duty, or is this some sort of federally crafted fiduciary duty that's in the 34 Act?
So in the tipping setting that we're talking about, where we are now at a remote tipper or a remote tippee, we're talking about a federally imputed duty, fiduciary duty, that is derivative to some original fiduciary duty at the origin. At the origin, that's often a matter of state law. So if it could be a duty of confidentiality, a contractual duty in the case of O'Hagan, or it could be state corporate law, like in the case of Delaware, directors have fiduciary duties, all states, to their shareholders. So the original fiduciary duty will often arise in state law, but the imputation of that duty to trading behavior towards counterparties that are far removed from the original source of the duty is really the creation of these cases, federal cases. Yes?
You mentioned something about people holding short positions a little while earlier, and I was just wondering, would that person be liable under the misappropriation theory or the classical theory? Because if we consider that person to possess that stock based on some sort of constructive trust, some property law principles, then perhaps that's a classical trading violation. Or if it's because the prospective buyer of that stock isn't really isn't an existing shareholder at the time the transaction is consummated. So I'm not sure whether that someone who holds a short position would be what theory.
Yeah. So great. So the question is, what is a short? How does short selling fit into this? Remember, the first step in a short sale is to borrow and sell the stock immediately. So the sale, the first step in the process, is a sale of a security, and thus we're in 10b-5. Where the duty originates, so it depends. If we're talking about, for the classical theory to hold, you need a fiduciary duty to the counterparty of that transaction. But that's going to depend on the facts. So we could work through some examples maybe after, but it could work either way with short sales. Felix, last one. Yes.
So this is a kind of a crazy hypo, but maybe it's not.
So for insider trading, yeah.
But so for insider trading to occur, for anybody to be liable, trading actually has to happen, right?
Yes.
So say that the CEO of Equity, the CEO of Equity Funding found out his employees were going to Dirks and were going to leak to him. So the CEO called up and said, "Hey, Dirks, guess what? We're committing fraud. And by the way, I'm getting so much benefit from telling you this because if you share this and it's traded on, I have a short on my or I'm shorting this." Or he makes some plausible case that there's a benefit to telling Dirks about that.
Yep.
Can he effectively disable Dirks from sharing the information that's given to him in good faith by other people?
Sure, I think you can think of even a simpler case, which is that there could be just a disclosure that I'm giving you this information pursuant to. I mean, I actually give you simpler. All you need is a duty of confidentiality, and you get Dirks on the misappropriation theory directly, right? So the case here was that Dirks acquired the information not pursuant to any kind of prior conversation. All you would need to do to bind Dirks, so to speak, to prevent him from tying, is just tell him he's receiving information in confidence. Cuban v. SEC, the Mark Cuban case, is a good reference for this. And Mark Cuban's on the phone, and he actually beat the SEC at trial. And his argument was, look, I never acquiesced, I never agreed to keep the information in confidence. There was no indication that fiduciary duty or duty of confidence was violated. Okay, let's move forward, just for the sake of time. SEC v. Yun. Who would like to tell us about Yun? We'll do this one quickly. Yes. Remind me your name? Lauren. Great. Yeah. Yeah. Yeah.
And her coworker, Bert, came in and kind of overheard what she was talking about. And then later, they went to like a cocktail party, and they like rode over together, and they like spent like 3 hours there. And then like the very next day, Birch like bought put options.
Yeah.
Scholastic shares kind of like over like half of what he made the year before, and like him been an active trader.
Yeah.
And he made 1,300% return on his investment.
Yeah, that's great. Exactly, Lauren. And the broker, what is it? Does the broker tell Birch anything? Did you remember that fact? What the broker tell his stockbroker? What does the stockbroker tell him? You're going to jail. Yeah, yeah. He basically says, you know, insider trading's illegal, buddy. And he says, well, no, don't worry, don't worry. Okay. So Birch makes a lot of money buying put options on Scholastica. What do you think, Lawrence? So what's the key? We're not going to spend too much time on Young, but what's the key holding of Young? So what is the 11th Circuit telling us in Young? What do we learn from this case?
So the fiduciary duty came from the spousal connection.
Yep.
And David had an expectation of confidentiality with Donna.
Yep.
Because of their past discussions on business affairs, and he asked her to keep it quiet.
Yep.
And not to trade on it or tell anybody about it.
Yep.
And then Donna's telling it to Ron caused the transfer of liability.
Yep. Yeah. So the question is really, is the marital relationship, or the dissolving marital relationship in this case, I guess, is that sort of de jure, as a matter of law, is that just enough to establish to satisfy the personal benefit test? And you said correctly that here the court says, look, they were sharing, they had a history or practice, is the terminology we read, of sharing business confidences with each other. Now, the key point why we're reading Young it's interesting to know that, and it's important to know that it's been superseded by Rule 10b-5-2, and that we now have specific SEC rulemaking on when, in fact, an existing sort of, well, we read in 10b-5-2, when two people have a history, pattern, or practice of sharing confidences, that will, in fact, be sufficient to satisfy this test. But what I want you to focus on is the reasoning here on how it is that this relationship establishes a personal benefit. Did you pick that up in the discussion? It's a little ambiguous, but there's. Do you remember anything on this? Yeah. Well, between the but also with Mr. Birch, right? So what the court is doing is saying, look, so the question here is whether or not the marital relationship is sufficient, but but Donna, when she shares the information with Birch, is not sharing it with Birch pursuant to any kind of confidentiality agreement. So we need to be able to show that Donna herself is benefiting from this disclosure, right? That's the key analytical step. You see that, right? So it's not enough. So it's not enough to say that that there is a duty of confidentiality between the Youngs, because we got to get Birch, trying to get Birch's trading. Okay. So how are these two connected? Let me pick this up. It's a little difficult in the squib that we get. Yes.
So Donna has this duty of confidentiality because the SC says if they can prove that the husband and wife had a history and practice of sharing such confidences,
Yep.
then in most instances the conveying spouse, that would be her husband, would have a reasonable expectation of confidentiality.
Yep.
So that's different than the Cuban case where Cuban's counterparty didn't have that expectation and he didn't acquiesce.
Yep.
So then Birch inherited that duty because he's a close friend of Donna's and works with her.
Yep.
And Donna allegedly receives a personal benefit a friendship
Yeah.
by conveying this information.
Exactly. Okay, does everyone see that? So this is a little application, a non-controversial application, but except for the marital part, sort of you should see how the relationship between Birch and Donna fits nicely into this close friend language that we get from Dirks. And as is typically the case, right, the courts are just going to assume that these close friends, that the friendship itself, you could think of it as like a benefit, right? And so if I'm giving my friend a stock tip, going to be happier with me, and that's going to help me. Maybe it didn't hurt that Birch was a close working associate of hers. But so Yun stands formally for the proposition that was later codified in 10b-5-2 that the history of sharing confidential business information can, in fact, give rise to a duty of confidentiality absent even without express agreement between a married couple. But it's also a useful exercise for seeing how the personal benefit test is applied. You have to start with who, in fact, is subject to a fiduciary duty, to a duty of confidentiality, and kind of trace person by person and articulate how it makes its way ultimately to the final party who's traded. Okay, is this clear? Are there any questions on this? It's a pretty trivial. Okay, so it's not, so even though Yun was trivial, it's far less trivial the way the law evolves from here. Now, I didn't give you Newman, so I'm just going to take a couple minutes and summarize what happened in Newman. And we'll talk about Salmon, probably Martoma tomorrow. But let's see how far we can get. So in Newman, we had a fact pattern not really so different from Martoma. So you had a couple analysts who were receiving information from insiders at Dell and NVIDIA, two tech companies. And they're passing this information on through various intermediaries, so to speak. There's sort of a chain, long chain, 3 or 4 people, until it finally reaches Newman and Chiasson, who are the traders who make $4 and $68 million respectively trading on the information they receive from the insiders, which is really just a heads up about Dell and NVIDIA's earnings announcements. Okay? So it's a very classical sort of story of analysts getting information from insiders and passing it along ultimately to traders. Now, the problem in Newman, and what's really bothering the Second Circuit, is that not only was the final trading taking place at many levels removed from the original insiders who broke their fiduciary duty of confidentiality in giving the tip, but in fact, the folks who were talking to each other in Newman were kind of almost arm's length in a way. We were talking about one analyst who's giving a tip to another analyst in kind of this sort of Wall Street, let's exchange favors style, but it really wasn't a trading relative or friend. It really wasn't. These weren't close friends in Newman, and what kind of teed up the Second Circuit's decision was the concern that the personal benefit test is kind of getting stretched beyond all recognizable form. And if you basically can follow this logic that we articulated 10 minutes ago, that any gift of information is a benefit to the giver, then when is there not a personal benefit? And you can kind of see this in Dirks. You'll say, well, the answer is when you're trying to expose a fraud, there's not a personal benefit. But wait a minute, even in Dirks, there was a benefit to all the folks involved, except maybe for Sechrist, but everyone else in the Dirks story is benefiting. So it's kind of hard to find a case where gift giving doesn't constitute a personal benefit if we follow this logic that all we need is this kind of psychological benefit to gift giving. And in Newman, what the Second Circuit did was kind of put the brakes on it and say, no, there is a point at which we cannot go forever down this road of any gift of information is a personal benefit. Because at the end of the day, that will sort of completely displace the personal benefit test. There will be no personal benefit test. What that would basically achieve is a rule against trading on material non-public information. And that is really kind of what the SEC wanted in Newman. And for those who know sort of the history of Bahara in his overall view that securities markets should be fair, and fairness means not trading on material non-public information. The Second Circuit felt, as of 3 years ago at least, when it wrote Newman, that Chiarella counsels us that is not the law. And you know that, right, going back to Chiarella, although Chiarella itself would probably be a violation under the misappropriation theory, today there's this hesitation to impose perfect information symmetry, which is what at least Preet wanted, it's what the SEC seemed to have wanted, or they at least wanted a very aggressive form of insider trading liability. And the hesitation here, we'll talk a little bit about the sort of policy of this tomorrow. It's tricky, right, from an economic standpoint to think about why. But what we saw in Newman was the Second Circuit coming up and saying, look, there needs to be something more. There needs to be a meaningfully close relationship. The exact language from Newman was the personal benefit inference from just having a relationship between the giver and the giftee is impermissible. That inference of a personal benefit is impermissible in the absence of a proof of a meaningfully close personal relationship that generates an exchange that is objective, consequential, and represents at least a potential gain of a pecuniary or similarly valuable nature. So what the Second Circuit did in Newman was kind of take the law back to this quid pro quo paradigm that we were discussing. There must be some actual benefit. Enough of the psychological stories and your family's happy, you're happy. You got to like articulate something real. And that, unfortunately, or fortunately, depending on your point of view, did not survive Salmon. So what happened in Salmon? Andrew.
So Salmon was the third link in a chain of insider information breach where the initial person worked for Citigroup and gave information to his brother, who then gave the information to Salmon. They were in-laws. And the initial insider knew it was going on.
Yeah.
But it wasn't ever his explicit intention to get the information to Salmon, who ended up making about $1.5 million.
Yeah. Yeah. So the brothers were like happy, Meyer and Michael, right? They were happy with kind of helping each other out. And the insider here, Meyer, who was a Citigroup analyst and knew, a Citigroup investment banker, knew that Michael, his brother, was trading. So he's not like off the hook here, right? He knew that his brother was trading. And he didn't really mind that. He didn't expect his brother to go pass it along to his buddy Salmon, who would like really trade and alert the SEC, right? So, you know, that was not in his expectations from day one. And so, Andrew, what is the, well, first of all, what's the issue here? What's the question? What's the defense? And how did this why did this make its way to the Supreme Court?
So Newman, if you take Newman literally, then there was no quid pro quo relationship. There was no fiduciary. There was no financial gain.
Yeah.
The initial links of the trading of the insider information chain.
Wait, who in particular, right? Because so is it that there's no gain to Meyer, no gain to Michael, or no gain to Salmon? Well, there's clearly gain to Salmon, right? So who in particular is the defense emphasizing here?
I believe it's the initial link, Maher, right?
Well, Maher, you know, that would be the weaker argument, right? Because Maher is giving it to his brother. But yeah, you might say that, you know, Maher isn't you know, he's not benefiting under the Newman test because the familial relationship in and of itself is not enough. There's got to be some true quid pro quo. We didn't have evidence of that here. We also didn't have much evidence of the quid pro quo on the next link of the chain. But there is this, the real issue in Salmon is the family relationship enough, right? And that's the harder one to, the easier one to establish under the language of Dirks. And so you would think that there wouldn't be much of a dispute around this issue because Dirks talks about a trading relative, specifically uses those words when it articulates the personal benefit test. A gift to a trading relative will provide the giver with a personal benefit under Dirks. But the argument is, look, the Second Circuit has sort of guided us to looking for an actual quid pro quo, and the language in Dirks was really sort of illustrative. It was just an example of it was just an example of that kind of quid pro quo. It wasn't like we shouldn't read that as establishing in all instances that a gift of information to a trading relative sort of as a matter of law creates a personal benefit. That's really the issue. And it goes back to our conversation around how it can be, like as Amy and I discussed earlier, how it can be that a gift creates a personal benefit. Well, you'd say, well, in the family context, I'm better off if my family's better off. I'm better off if my brother's better off. You got to kind of make one of those assumptions, right, which assumes we're not estranged or whatnot. So, Andrew, what does the Supreme Court do?
They clear Dirks easily resolves the issue.
Yeah. We don't need to worry about the big question of whether a gift is actually a benefit to the giver, right? We'll just focus on the narrow issue, which is easily resolved by Dirks. And?
So, anytime, it pretty much overrules movement.
Yeah.
You don't need to have an actual pecuniary gain for there to be liability.
Yeah, exactly. So Salmon's a pretty narrow but important holding, and the holding is just the gifts of information between family members is enough. Full stop. That's it. Take the language of Dirks as it is given. No pun intended. And don't even try to understand what a gift is or isn't. Just a gift of information to a family member is enough. Okay, so then we get to Martoma, right? So we'll talk as much as we can in the next 9 minutes about Martoma. So Martoma is this part of, I sent you guys an email with a link to this book that's been written about the Stephen Cohen sort of saga, right, over the last 7 years or more, that Preet Bharara was trying to take him down, this hedge fund king. And he got very close, and Martoma was really in the inner circle, but he wouldn't flip, or, as defenders of Mr. Cohen would say, he had nothing to say that would criminalize, that would allow them to pin this on Stephen Cohen. But this was a practice. It's actually interesting if you read the book that I sent you the link to. It's kind of a cool story, because what Steve Cohen would do is say, look, I don't want to know where the information comes from. Don't tell me where you got your information. Just tell me how confident you are on a scale of 1 to 10. And it turns out that that is enough to get you off the hook criminally. And you can see why, right? Now you can see why, because if you're not aware that a fiduciary duty has been breached, you are off the hook. So in fact, Martoma, he oversees 500 million in assets, and he starts to develop a relationship with Dr. Sid Gilman. Tragic story of Dr. Gilman, for those who are interested in reading. He was a true star, and in his 80s, I guess it was, just things went downhill here, and he started, and it's a fascinating psychological question, sort of why he started talking to Martoma. Was he flattered by the attention? He was getting, actually, a key fact, he was getting paid by Martoma, right? He was getting paid $1,000 an hour. And, but it didn't seem, at least from some of the sort of portraits of Dr. Gilman that we read, it didn't seem that Dr. Gilman was 100% motivated by money. I think he just found Martoma to be fascinating. At least that was his testimony. And here's a guy who really understands how Alzheimer's trials are working. And Martoma would come with his sort of charismatic style, and would start talking about things like p-values and all this sort of deep scientific knowledge, and Dr. Gilman was just stunned, And the psychology of this is kind of cool to think about. So in July of 2008, Dr. Gilman gets unblinded. He's the chairman of the safety committee for this Bapinuzamba substance, and he learns the results on July 17th that the clinical trials were disappointing, that there's some concerns about the efficacy of the drug, and there's a 12-day period, from July 17th to the 29th, when he is in fact in communication with Martoma, particularly the 17th, 18th, and 19th of July. He's having conversations with Martoma. Martoma flies out to Ann Arbor, where Dr. Gilman is. And Martoma begins to trade on this information before Dr. Gilman's public announcement of the results at a conference on July 29th. So July 29th comes around, and Dr. Gilman stands up and says, these results are disappointing. By that point, Martoma and Cohen have made a mind-boggling nearly $300 million, 280-something and change, 275 million and change, on selling short these two companies, Elon and Wyeth, or unwinding their long positions. And so the issue in Martoma is how far the Second Circuit will take the application of the personal benefit test, or I should say the Supreme Court's view in Salmon that the personal benefit test is established via a gift to a trading relative or friend. One problem in Martoma is that Dr. Gilman and Martoma are not close friends. Okay? They are just sort of casual. They're actually in a consulting relationship through an expert network firm that Martoma's hedge fund is contracted with. And so that sort of raises 2 points. The first is that it seems unnecessary to talk about the trading relative or friend prong, so to speak, of Dirks, because you could probably just say there was a quid pro quo here. The quid pro quo was the $1,000 an hour payment. That's what the doctor received, and in return, he gave Martoma the information. Now, there was this claim that maybe those weren't causal to each other, that, he would have been paid the consulting fee either way. It seems like these meetings wouldn't have happened otherwise, so that probably is a pretty solid basis to find Dirks, liability under Dirks. But, in fact, the Second Circuit goes much further, and not only sort of embraces Salmon, but says Salmon changes the law of insider trading. In the following way, Salmon requires that we hold that an insider or tipper who personally benefits from a disclosure, whenever that information was disclosed with the expectation that the recipient would trade on it. And this is a radical expansion of the personal benefit test, or elimination of the personal benefit test, you might say, almost to the point where it's not clear anything will not qualify as a personal benefit, because giving information with an expectation, right, that your counterparty is going to trade on it is really like exactly what Mr. Dirks did, right? So even though Mr. Dirks, is not derivatively liable because the original breach was not a violation of fiduciary duty because it didn't have this profit motivation, this personal benefit motivation, and there was the information originally wasn't given with this expectation of trading. Dirks is talking to all these folks about this opportunity, right? This sort of fraud that you should trade on, by definition, unwind your position. So, tomorrow we'll think more about this because there's something really, really broad about the construction of the personal benefit test in Martoma, and it would seem to sweep in not only Dirks' own behavior, but it's hard for me to think of a disclosure of material non-public information that is not made with an expectation that the recipient will trade on it. Ben?
I know we're supposed to get going, and I apologize to everyone. One thing that I find really, really interesting is that the court says Salman tells us this is really what Salman means, even though it doesn't say whatever. The way you just phrased it was great. What I think is so interesting about that is in Salman, the government argued that a gift of confidential information to anyone, not just a trading relative or friend, is enough to prove securities fraud. And in doing so, the government also noted, and I'll just read right out of it, that to establish a defendant's criminal liability as a tippee, it must prove that the tippee knew that the tipper breached a duty. In other words, that the tippee knew that the tipper disclosed the information for a personal benefit and that the tipper expected trading to ensue. It's And that's exactly what the court declined to follow in Salman.
That's right.
To say that Salman tells us to do exactly what Martoma does, which I have no normative complaints necessarily with Martoma, but is just totally going against what Salman
Yeah, Ben is
did.
exactly right that the court rejected in Salman, the view that the government's claim, this is like what the SEC has been trying to, was Preet Bharara's sort of whole thesis, that if you give material non-public information knowing that the recipient's going to trade on it, that is illegal. That is a violation of 10b-5, and that was rejected. And the Supreme Court said we're only going to decide on the narrow grounds of trading relative or friend. The Second Circuit embraced that much broader interpretation despite the language in Salman where the court says, no, we're not going to follow the government's proposed view. Okay, on that excellent point by Ben, we'll wrap up for today. I'll see you tomorrow. We'll continue this, and then we'll start the civil liability cases in Reg FD. See you tomorrow.
Yeah. And my first instinct was to say, like, oh, like, you know, carbon emissions and all that. And literally when I got home and logged onto the internet, they were talking about the new carbon, the Trump White House with, you know, managing carbon emissions. So,
see, it's very profitable to work in this White House, but, you know, I was reading that there is some skepticism now about whether Trump's tweets will actually move the market, right? There's a sense that even in the Amazon case, a lot of commentators are saying, you know, the guy doesn't follow through on anything he says. So you shouldn't start buying and selling on the basis.
It's just noise.
It's just noise. So, you know, that would, of course, be problematic for a lot of reasons. You know, because you wouldn't have materiality, arguably you wouldn't have materiality in the probability of magnitude test. You probably couldn't get fraud on the market because you wouldn't have a price change. So anyway, it's an interesting question. But yeah, that's good. Oh, hi, I'm sorry. Yeah. Oh, no, we have more than that. Oh, yeah, yeah. The last class is the last class for the academic calendar. Yeah. I mean, the registrar gives us a certain number of classes, and they give us a certain number of teaching hours, like classroom hours, and they put in, like, the last day of classes, and I just follow that. So I think the last day of class is it's a Wednesday, April 26th, I want to say. Does that sound right to you? Yeah, so the last week to give you guys time to study. I might. Let's see how much material we get through. Well, we got a lot of snow days. I feel like I'm cheating by not doing makeup classes, but you're not complaining. So we'll see. We'll see how much material we get. Other professors are canceling classes. Okay. Yeah, go ahead. That's good. Yeah. Yes. Well, she goes to the cocktail club, but she does give it to me, right? I mean, he's in the room while she's on the phone.
Yeah, but we're saying, but technically she wasn't giving the phone. Is that even
well,
that person that interacted and let me tell you about it?
You mean to say it was inadvertent from her perspective? Well, sure, but you could say that there was a breach of her duty of confidentiality when she discussed confidential matters in her office, right? Right, but there doesn't need to be an expectation of benefits affirmatively proven if you're giving a gift of information. We should walk well, so fair. So she, but I don't think the claim was persuaded. I think the claim was, look, she's here. You can't say that she
You might be.
you're not going to get off the hook to give someone
Because there's a panel, right? Because there's a panel,
right? Like that would be
yeah.
But I think there's some
Correct, yes. But bonus is outside. In case there's a problem, just give them. But I'm gonna zoom out so that they'll be able to see. Microphone. And who this is for? For yeah, I know who that's for. The professor.